चलिए let's see Article 13 basically. Let us give the reading to Article 13 first of all. So we have done Article 12 last time. We are moving towards Article 13. Article 13 is the starting line of fundamental rights to understand. Uh, so first of all, we give the reading, just basic reading to Article 13. What is the Article 13 says, and then only we will understand the concept. So if you see Article 13 have 4 clauses. Right, fourth clause was added by 24th Amendment, and we have studied this clause very well while we are studying 368. So the fourth clause is the clause added in this fourth clause added in 24th Amendment, and we have studied this while we are studying 368. We have studied this. So today's class, our focus will be of starting 3 clauses. Article 13, the marginal heading. The marginal heading of Article 13 is law inconsistent with or in derogation to the fundamental right. Basically, Article 13 is a bar upon the legislative power, or I can say it's a check on upon the legislative power, or I can say it is a guiding principle for the legislature. What is this guiding principle says? This Article 13 says that the Parliament, no law must, I will say before getting, as we have not read out this, so we'll try to understand in very layman language. The Article 13 basically says you have no right to frame, or no law can survive in contradiction to part 3 of the Constitution. देखिए Article 13 is talking about unconstitutionality of law. So basically this article says that the law is unconstitutional if it is against part 3rd of Constitution. So anything which is in part 3rd of the Constitution, that is against the, and nothing is allowed, no law is allowed apart from fundamental rights. So you cannot go beyond fundamental rights. You cannot do anything which is beyond fundamental right. Basically this law is trying to say this part. So let us try to understand what this law is saying. So let us give the reading. So let us give clause 1. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provision of this part, shall to that contest to the extent of such inconsistency. First of all, this clause 1 is basically talking about pre-constitutional laws. So Article 13 says, suppose this Article 13 is saying if any law is existing, any law in force before the enactment of Constitution will not be in force now if it is against the FR, that is part 3. So they says if anything which is against part 3, so what they're saying, all law in force. What do you mean by all law in force? That means all law are already existing. All law in force mean existing law. They are talking about existing law. They are talking about the existing all law in force in the territory of India before the commencement of in force before the commencement of constitution. When they say before the commencement of constitution, that they mean to say the law which was existing was with they are talking about pre-constitutional laws. Huh? This is the situation of pre-constitutional law. Pre-constitutional law. Laws which were in force before the constitution of so far as they are inconsistent with the provision of this act. So far as inconsistent. So far as we use black. So far as inconsistent with the provision of part 3. So far as, what do you mean by so far as inconsistent? They are not declaring the pre-constitutional laws void as such. They are not declaring the laws void. They are saying the Article 13 not declaring the complete law void. Rather, I will say it is not saying that pre-constitutional law are not in force. They are not talking about in uh, end of the enforceability of pre-constitutional laws. Article 3, Article 13 is not talking about the enforceability or non-enforceability of the pre-constitutional law. Rather, what it's saying, the pre-constitutional law which are against the part 3rd will become unenforceable. The article is not talking about the non-enforceability of pre-constitutional law. They are talking about that any part which abridges the 3rd provision. Okay, that it. This is known as incontroversion. Okay, that is why. Now next they use the word to the extent of such inconsistency be void. To such inconsistency. Try to understand. To such inconsistency be void means may be possible that the law complete may not be void. Okay? So some portion of that law may become void. Not necessary complete law to be void. Some portion may be void. Void due to inconsistency. To part 3. So try to understand two things, make it understand in your mind. Two things you should keep in mind. Firstly, the para 1, clause 1 of article 13 is not declaring that any law which was existing prior to the constitution is now void after the uh, freedom or after the constitution. What they are saying, they are still enforceable, but if they abridges or they try to infringe any fundamental rights or any provision of the 3rd part of the constitution, to that extent they may become they are void to that extent. And this is the part. I mean, we are reading a bare act. We will go into the concepts also, don't worry. We'll go into the concepts. But this is the first clause where how many people understand this first clause of the bare act. Anybody having any question regarding this? Chaliye, nobody is having question right now. Let us go into clause 2. Just want to give the reading of these clauses. First and 2 only. We'll go do first and 2 clause reading. Try to understand the basic and thereby we go into the concepts also. Let us read the clause 2. So clause 1 is very much clear, very clear, that it applies to pre-constitutional law, the law which were existing prior to the constitution, and now after the constitution, either the law completely or due to some provisions have come into the direct conflict with the part 3. Then the conflicting part will be considered as unconstitutional or void. Whereas clause 2 imposes the duty. The state shall not make any law which take away or abrogates the right conferred by this part. That is the duty upon the state. It casts the duty upon the state. The state cannot make any law that is against the fundamental rights. Fundamental right of the Constitution. Against the fundamental right of the Constitution. That is part 3rd. That is part 3rd. And that is, you cannot make any law which is against the part 3rd. That is, this says if any law is made in contravention to part 3rd. Any law made in contravention to part 3rd, it is void to that extent. So basically, this clause is talking about post-constitutional law. Clause 1 is talking about pre-constitutional law, whereas clause 2 is talking about post-constitutional law. तो दो provisions हैं, constitution आने से पहले और constitution आने के बाद. तो 1949 के बाद और 1949 से पहले. तो if this is 1949 constitution came into force, इससे पहले 13 clause 1 और इसके बाद 13 clause 2. This is how. Ab we have to understand this, how this law and how they are working. So clause 2 is talking about post-constitutional law, whereas clause 1 is talking about pre-constitutional law. आप एक चीज देखेंगे जनरल डिस्कशन के में आया तो मैं यही डिस्कस कर लेता हूँ. If you see, they use the word contradiction. If you see, they use the word contradiction in clause 2, whereas they use the word inconsistency in the clause 1. If you see these two words, if you can see, they're using two different words. Why they are doing? Because in both the situation they are making it declare void, but in the first clause they are using the word inconsistent, whereas in second they are using the word contradiction, a contravention. Why are they doing? Basically they are trying to make you focused that the time when these law was existing, the word inconsistency shows that these laws were valid. And these laws were valid because the time when they were made, there was no fundamental right was existing. And now they become inconsistent, now they become unfavorable because the constitution has came into force. However, the word contradiction shows that the enactment per se is voidable from the very beginning because it has been made in the contravention. So fundamental right, the day on which the law was made, it was a fundamental right were existing. And due to the existence of fundamental right, this law has never come into force. कभी force में ही नहीं आया. ये difference है basic the word inconsistency का और contravention का. So let us go into first clause and try to bring out how these things are working. So this is, तो एक चीज समझ में आ गया, it applies upon the pre-constitution law. How they applies upon the pre-constitutional law? Basically, what happened? First question is, do the clause 1 declares makes the do clause 1 make law wide ab initio? Do it make law wide ab initio? क्या provision word ab initio? Answer is no, it does not make the law wide ab initio. Rather, it does not make the law wide. Rather, it never make law wide. Rather, what happened? What has happened? Rather, it become enforced. It stopped being enforced after the fundamental right hand came into forces. Its enforceability is no more existing. No more existing. देखिएगा clause 1 के अंदर they are using the word void, but this void does not means void ab initio. Rather, this void means it is not enforceable from the date of the constitution. So for example, let us take up one example. Suppose there is a law that a, let us pick any example. So I will pick a general example, make an example that untouchables are not allowed to visit mandir, and this is a untouchability law existing. This is some untouchable law, untouchable protection act. Suppose this is the act 1741. I'm just creating, या फिर let is 1841. I'm just creating an ideology. ऐसा कोई प्रोटेक्शन एक्ट है नहीं, बट एक एग्जांपल क्रिएट करने की कोशिश कर रहा हूँ कि सपोज देयर इज एन एग्जांपल दैट 1841 में देयर इज अ लॉ that no untouchable should be allowed to visit the mandir. Now what has happened? This law is into function, going on. What happened in 1949? What happened? Constitution has come. And what happened? Article 17 come. Now what? You cannot make any law which promote untouchability, right? You cannot make any law which promote law that promote untouchability is not allowed. So what has happened? What has happened? This law is cannot be enforced after this. But does this law lose its identity in backside? 1841 से लेके 1949 तक जो इसमें हुआ, does that loses its identity? Answer is no. What has happened between 1841 to 1949? ठीक है, it will not be affected. It will not be affected. It will not be effectively. So basically, what has happened? This law is still into function. This law is still remain in function, but prior to 1949. After to 1949, it is not in function. Let me take one example more, and we try to understand what it is happening. So this is pre-constitutional law. Let us take another example, and we try to pick up the very good differential. Let us create one more example. Suppose there is some law. Let us make a make some provision which is now punishable but earlier was not punishable. Yeah, earlier it was punishable but now it is not punishable. So suppose let us take up example of bigamy. Let us take the example of bigamy. Bigamy allowed, और इसके ऊपर suppose some law is there. Bigamy allowed act. Suppose there is some law, some act is there. Bigamy allowed act 1848. And the persons are doing bigamy till 1949. And 1949 में constitution came. And constitution came, and suppose the constitution have fundamental right that bigamy is offense. Suppose this is the fundamental right now. All is hypothetical. I'm always all thing has been hypothetically created by me. ऐसा कोई law नहीं है, ऐसा कोई fundamental right नहीं है. But हम hypothetically एक situation create कर रहे हैं कि bigamy, मान लो एक law था bigamy allow act 1848 और 1949 में कॉन्स्टिट्यूशन आया, उसने बोला फंडामेंटल राइट में कि बाइगेमी इज नाउ ऑफेंस. दैट मींस यू कैन नॉट क्लेम बाइगेमी, मोनोगेमी फॉलो करनी है. दैट मींस इसके बाद से ये लॉ अनकॉन्स्टिट्यूशनल हो गया. दैट मींस एनी पर्सन who do bigamy after 1949 will be punished. Am I right or not? Any person who will do bigamy after 1949 will be punished. But what about the person who have committed bigamy? Who committed bigamy before 1949? Do they will also be punished? मैं वहीं आ रहा हूँ भूपेंद्र, उसी एग्जांपल को क्रिएट कर रहा हूँ. What happened to person who committed bigamy before 1949? Do they will be punished? क्या इनको भी पनिश करना पड़ेगा? Do they will be punished? Answer is no. They will not be punished. Answer is no. Because 1949 के बाद, because clause 1 have prospective effect. Article 13 clause 1 have a prospective effect. समझ लेना. This means this shows Article 13 clause 1 is not retrospective. Rather it is prospective. तो आर्टिकल 13 क्लॉज 1 कब से लगता है? रेट्रोस्पेक्टिव नहीं है, ये प्रोस्पेक्टिव है. ठीक है. दिस इज आल्सो बीन हेल्ड बाय सुप्रीम कोर्ट. ये लिख भी देता हूँ, कोई इतना इंपॉर्टेंट जजमेंट नहीं है, फिर भी लिख देता हूँ. ठीक है. महिंद्रा वर्सेस स्टेट ऑफ उत्तर प्रदेश 1963 सुप्रीम कोर्ट. एंड ऐसे बहुत सारे जजमेंट है, बिकॉज इट इज अ सेटल्ड लॉ. तो डोंट नॉट वरी. ठीक है. इसके अलावा बहुत सारे जजमेंट मिल जाएंगे. मैंने आपको एक एग्जांपल लिया. तो वन थिंग इज वेरी मच क्लियर इन द माइंड दैट इट इज अ प्रोस्पेक्टिवली अप्लाइड, नॉट रेट्रोस्पेक्टिवली. जो पीछे हो गया उसको फर्क नहीं पड़ने वाला है, जो आगे है उसको फर्क पड़ने वाला है. कितनों को ले बात समझ में आती है प्लीज? हाउ मेनी पीपल हैव अंडरस्टैंड दिस कांसेप्ट? क्योंकि किसके बाद में इसके किसी और कांसेप्ट में जाना चाहता हूं. तो ये प्रोस्पेक्ट, पहले तो ये प्री कॉन्स्टिट्यूशनल लॉ पे लग रहा है और ये प्रोस्पेक्टिवली लग रहा है, आगे से लग रहा है. उसी चीज को लेके पीछे जो हो गया है उसको कोई इफेक्ट नहीं करने वाला, या पीछे जो हो रहा है अभी भी उस पर कोई इफेक्ट नहीं आने वाला इससे. Am I right? How many people have understand this concept? चलिए, तो एक चीज समझ में आ गया कि this applies prospectively. अब what has happened when I say it is applies prospectively? What is happening basically? Basically what is happening, the law is not ending. The law is not getting over. The law is not getting over. When I say law is not getting over, what does it mean? That it is not ending of the law. it is not becoming void. Law is not becoming void. Rather, it is getting eclipsed. The law is getting eclipsed. So basically, the first Article 13 Clause 1 talk about the doctrine of eclipse. So basically Article 13 Clause 1 talks about doctrine of eclipse. So it is a doctrine of eclipse given by Justice Das. This time, first time, this name was given by Justice Das. Justice Das in Bikaji versus State of Madhya Pradesh. And this is the landmark judgment on this topic, 1955. This is where Justice Das discussed Bikaji versus the State of Madhya Pradesh. He discussed what is doctrine of eclipse. So what he's saying, what do you mean by doctrine of eclipse? So we all know what is eclipse. How many people know what is eclipse? Eclipse पे कुछ नहीं होता है. Eclipse को समझने की कोशिश करते हैं. Suppose this is, I will make it more clear. Suppose this is one thing and this is another wall. And suppose this is the light. If I put the light on this, what happened? This will get shadowed. I know. This small portion will be shadowed by the building. For example, if you see Chandra Grahana, जिसको something ग्रहण सुना है? ग्रहण सुना है? For example, धरती है and this is चांद. Suppose this रोशनी का प्रोसेस है, they are into this. अचानक से कोई चीज बीच में आ जाती है. And what will happen? This will not clear. What will happen? This shadow will come over this. है ना? Shadow आ जाएगी बीच में. जब shadow बीच में आ जाएगी तब क्या होगा? Does it means that this moon has got ended? Does it mean this is no more? It is existing, but it has been overshadowed. It exists, but become overshadowed. तो जब इस दीवार के ऊपर रोशनी गिरी तो मैंने इस दीवार के ऊपर जैसे ही लाइट लगाया तो बड़ी दीवार की रोशनी शैडो छोटी दीवार पे गई. क्या छोटी दीवार खत्म हो गई? It has not get overed. What has happened? It has become overshadowed. It has been shadowed by the larger wall. Similarly, what has happened? Suppose an enactment is going on, a law. This is a law. Law is going on. And this is how this law is going on. Into the society, this law is going on. Achanak se what has happened? The constitution come into exist. The constitution came into exist. Now the constitution came into exist. The shadow applies upon the constitution on Article 13. And now what is coming is the shadow of the light is coming off the shadow of this. Shadow of constitution. The shadow of constitution is coming, but it does not mean that this law is not existing. This law is existing, but It is not now being shown. So this law is not over. The law still exists. The law still exists. But what has happened? Due to part 3, it is not effective anymore, being in derogation of part 3. So what has says what Article 13 says? Article 13 says that any person who is in derogation to any law and derogation of the Constitution will not be effective from in future. This is known as doctrine of eclipse. तो बेसिकली प्री कॉन्स्टिट्यूशन लॉ पे आर्टिकल 13 क्लॉज 1 डॉक्ट्रिन ऑफ इक्लिप्स को लगा देता है. व्हेन आई से, अब मैंने इक्लिप्स का एक फैक्टर समझाया. दिस इज द वन पोर्शन ऑफ इक्लिप्स. यू हैव अंडरस्टैंड वन पोर्शन की इट इज नॉट एप्लीकेबल इन फ्यूचर. मैं आपको बताने की कोशिश कर रहा हूँ डॉक्ट्रिन इक्लिप्स के बहुत सारे फैक्टर्स हैं. फॉर एग्जांपल दिस लॉ, अब समझ के देखना. Law is not inconsistent with part 3 but inconsistent to part 4. बताइए what happened to this law? What happened to this law after constitution coming, after constitution force? What happened to this law? What has happened? The law which was existing prior to the constitution is not in derogation to part 3, but it is in derogation to part 4. What will happen? This law will still apply. This law will still apply because doctrine of eclipse यहाँ नहीं लगेगी. एक और example. Law is in derogation to part 3 article. Let us take up the article which is available to citizen. Which articles are available to citizen? 17. Article 17 available to citizens. 15 available to citizen. 16 available to citizen. Am I right or wrong? 14 is available to every person. What about 21? Everyone. What about 20? Only to citizen. 23 only to. There are so many articles. So let us take about 20. 20 also talk about 20 is available only to the citizen. Am I right? Let us check it. Let me check first. Okay. Let me confirm it for you people. That's name. This is not a person, not 21. We'll go with 17. So we'll go with 17. 17 is available to the citizens. Okay, 17 and 18 is available to citizen. So I will go to, I will pick up the example of 18. Title, Article 18. Let us, this is applicable. Law is in derogation to part 3, Article 18. That is no title. No title to citizen. Or I can use, yes Shri, I can use 19. That is freedom to speech. Freedom to speech. These are two articles which I can use. So Article 19 or Article 18 I want to use. The law is in derogation to Article 18 or Article 19. That means freedom of speech. So there is a law which is, so there is a law that bars citizen to criticize the government. Citizen, or I will say citizen and non-citizen. So what there is a law existing, that bar is there that citizen or non-citizen criticize नहीं करेंगे, ठीक है? They will not criticize the government. Constitution came in force. Article 19 says freedom of speech includes criticism, right? Freedom of speech includes criticism. And hence, law void. Law become dormant, law become void. But tell me, does this law still can be used? समझ मेरा सवाल समझना. There is a law on Article 19 which is in direct contradiction with Article 19, and it says that law that bars the citizen, the law bars that citizen or non-citizen cannot criticize the government. The criticism of the government is being barred, and it will get in conflict with Article 19, and it was declared unconstitutional. My question is this: after declaring constitution, can this law still be used in 2002, 20? Can this law still applicable in 2020? बताइए. Can you use this law in 2020? बोलिए. Yes. कैसे? For non-citizen. Because yes, it is for non-citizen. Because this laws applies to both citizen and non-citizen. Or this Article 13 says to that extent it is inconsistent. To what extent? Article 19 is only available to the citizen and not to the non-citizen. For non-citizen is still working. So this is why that is known as doctrine of eclipse. That is pre-constitutional law will get dormant under the constitution, and if they get in conflict with only part 3, then only they will get eclipsed. And what does it mean? That they are still in function if the act is prior to. Suppose some certain law is there which has been declared void today, but some act void today, that is a pre-constitutional law which is declared void today due to the infringement of any fundamental right, and some act under that law has been done which is made punishable now, which is not punishable but it was punishable prior. Okay? That prior act will still be made punishable because that this act was done when the law was in force. That is why this is known as doctrine of eclipse. ये बिल्कुल अगर हम अच्छे से समझने की कोशिश करें तो उस तरीके से जैसे बाइगेमी, जैसे अडल्ट्री, आई विल से अडल्ट्री. तो अगर मैं बहुत छोटा सा एग्जांपल डॉक्ट्रिन ऑफ एक्लिप्स को समझाने की कोशिश करूं अडल्ट्री से, तो 2017 में अडल्ट्री वाज डिक्लेयर्ड दैट इट इज नॉट अ ऑफेंस. 17 या 18 में थ्रू अ जजमेंट जोसेफ साइन वी गेट टू नो कि इट इज नॉट ऑफेंस एनीमोर. ठीक है. बट सपोज एनी पर्सन हु हैज कमिटेड अडल्ट्री इन 2016, 2015 or 2018 13, can he have a right to take the defense that adultery is not offense, therefore I will not be punished? Can he have a right? Answer is no, because Joseph Sign has prospectively applied. Yani ki what has they have not said the adultery is not offense from the beginning. It is not offense from now onward. That means anything which is done prior to, for example, Mithu Singh 2303 IPC, for example 377, they are declared unconstitutional now. So suppose any person who has been punished for 377 in 2000, can he claim compensation now because you have punished me in 2000, which is not the offense, so you have infringed my fundamental right, and now you have to compensate me if it is done. फिर क्या होगा? There will be a flood of legislations, because same way 303 में there's a death penalty. तो समझो मिथु सिंह से पहले जिन लोगों को डेथ पेनल्टी दे दी, क्या वो सारी डेथ पेनल्टी अनकॉन्स्टिट्यूशनल हो जाएंगी? नहीं. इस तरीके की रूलिंग प्रोस्पेक्टिवली अप्लाई होती है. ठीक है. तो वो जो पहले था उन पे, तो फॉर एग्जांपल जिसने अडल्ट्री पहले की है उनको आज भी अडल्ट्री लॉज के अंदर ट्रायल चल रहा है, बट यस उस तारीख के बाद से अब जो अडल्ट्री होंगी उनको फिर शायद क्रिमिनल ट्रायल नहीं मिलेगा, फिर वो ग्राउंड ऑफ डाइवोर्स हो सकता है. सेम वे अगर कोई लॉ कॉन्स्टिट्यूशन में 1949 से पहले एग्जिस्ट कर रहा था और उसमें कोई ऑफेंस हो गया है और वो ऑफेंस अब अनकॉन्स्टिट्यूशनल डिक्लेयर हो गया, बट वो पहले हो रखा है, तो उसके ट्रायल अभी भी चलेंगे, उनकी पनिशमेंट अभी भी उसी तरीके से मिलेगी. दिस इज नोन एज डॉक्ट्रिन ऑफ इक्लिप्स. और पूरा लॉ अनकॉन्स्टिट्यूशनल नहीं होता है. पार्ट, कितना पार्ट? जितना पार्ट 3 के कॉन्फ्लिक्ट में है, और ओनली फॉर पार्ट 3 कॉन्फ्लिक्ट. पार्ट 3 के अलावा किसी और लॉ में कॉन्फ्लिक्ट है, ठीक है, तब वो यहाँ पे 13(1) में अनकॉन्स्टिट्यूशनल नहीं हो सकता, वो कहीं और हो जाएगा, बट 13(1) में नहीं होगा. 13(1) या 13(2), यानी कि आर्टिकल 13 में सिर्फ और सिर्फ वो लॉ अनकॉन्स्टिट्यूशनल डिक्लेयर होते हैं जो डायरेक्टली हिट करते हैं अब्रिचमेंट ऑफ फंडामेंटल राइट्स, उसके अलावा नहीं. दिस इज नोन एज डॉक्ट्रिन ऑफ इक्लिप्स. कितने को समझ में आया डॉक्ट्रिन ऑफ इक्लिप्स? डॉर्मेंट हो गया वो लॉ मरा नहीं है, वो लॉ खत्म नहीं हुआ, इट इज बीइंग जस्ट डिक्लेयर डॉर्मेंट. प्लीज, कितने लोगों को, हाँ, हाउ मेनी पीपल हैव गॉट इनटू दिस? किसी को कोई सवाल प्लीज यहाँ तक? लेट अस गो इनटू क्लॉज 2. आई सिंपली स्तुति और सिंपल सी फंड है. मैंने एक एडल्ट्री का एक सिर्फ बहुत छोटा एग्जांपल दिया है. आई एम टॉकिंग अबाउट एनी लॉ. फॉर एग्जांपल, यू पिक अप एनी लॉ व्हिच इज डिक्लेयर्ड अनकॉन्स्टिट्यूशनल टुडे. तो सपोज हम 13(1) का एग्जांपल से हटके एक लाइफ एग्जांपल दे रहा हूँ. 13(1) के एग्जांपल अगर पिक करें तो फॉर एग्जांपल कोई लॉ एग्जिस्ट कर रहा है 1940 से, और वो चलता आ रहा है. 1949 में कॉन्स्टिट्यूशन आ गया. कॉन्स्टिट्यूशन का आर्टिकल 372 कहता है कि जो प्री कॉन्स्टिट्यूशनल लॉ हैं उनको इन्फोर्सिबिलिटी मिलेगी, दे आर इन्फोर्सिबल. आर्टिकल 13(1) कहता है बट दे आर नॉट इन्फोर्सिबल इफ दे आर इनकंसिस्टेंट टू द फंडामेंटल राइट पार्ट 3. तो सपोज एक लॉ है जो पहले से चलता आ रहा है और अचानक से कॉन्स्टिट्यूशन आया, और कॉन्स्टिट्यूशन में एक फंडामेंटल राइट पहले तो थे नहीं, पहली बार है कॉन्स्टिट्यूशन में 1949 में. तो जब पहली बार आया तो पता चला वो उस फंडामेंटल राइट, राइट टू प्राइवेसी वाले राइट पे या फिर फ्रीडम टू स्पीच पे कॉन्फ्लिक्ट में है, तो उसको अनकॉन्स्टिट्यूशन डिक्लेयर कर दिया. यानी कि 1949 के बाद उसे फॉलो नहीं किया जाएगा, बट उसी लॉ के अंडर बहुत सारे लोगों को सजा मिली होगी, बहुत सारे लोगों का ट्रायल चल रहा होगा अभी भी, है ना. व्हाट हैपेंड टू दोस पीपल? तो जिनको सजा मिली है वो भी वैलिड है, और जिनका ट्रायल चल रहा है वो ट्रायल अभी भी चलेगा, फिर चाहे उसकी पनिशमेंट कभी भी अनाउंस करें, बिकॉज दे हैव डन द एक्ट प्रायर टू दी कॉन्स्टिट्यूशन. यानी कि उसके उस लॉ के अनकॉन्स्टिट्यूशनल डिक्लेयर होने से पहले उसका क्या किया हुआ था, उसमें एक्ट किया था, इसलिए वो एक्ट अभी भी पनिशेबल है. क्यों? क्योंकि ये प्रोस्पेक्टिवली अप्लाई होता है. 13(1) रेट्रोस्पेक्टिवली अप्लाई नहीं होता है, पीछे से अप्लाई नहीं होता, आगे से अप्लाई होता है. तो मैंने बोला आज के बाद से. तो सपोज मैंने कोई एग्जांपल सेट कर दिया कि आज के बाद से मैं किसी को क्लास रिवाइज नहीं करने दूंगा. आज के बाद से, व्हेन आई से आज के बाद से, व्हाट डज इट बेसिकली मीन? कि अब के बाद जितने लोग पास होंगे. बट सपोज मैंने इससे पहले जिन लोगों को वो दे रखा है, परमिशन दे रखा है कि आप रिवाइज कर सकते हो क्लास, व्हाट हैपेंड टू दिस? क्या वो लोग भी बैन हो जाएंगे? नहीं, उनको अभी भी अलाउ करता रहा जाएगा. तो दे माइट कम स्टिल, बट यस, आज के बाद से वो लोग नहीं अलाउ आएंगे. दिस इज नोन एज डॉक्ट्रिन ऑफ इक्लिप्स. कि मेरा एक नया रूल जो आया है उसने मेरे पुराने रूल को ओवरशैडो कर दिया है, छुपा दिया है. इसका मतलब वो नहीं है कि वो रूल पावर में नहीं है, वो रूल पावर में है, वो पीछे चल रहा है, उसकी एग्जिस्टेंस है, वो पीछे है, लेकिन क्यों? क्योंकि अब से नई एग्जिस्टेंस आ गई है. दैट इज नोन एज डॉक्ट्रिन ऑफ इक्लिप्स. ठीक है, ये बीकाजी वर्सेस स्टेट ऑफ मध्य प्रदेश में पहली बार जस्टिस दास ने डिलीवर की थी, मतलब इंडिया के अंदर डिलीवर की थी पहले. लेट अस गो इनटू क्लॉज 2. कितनों को समझ में आया क्लॉज 2 प्लीज? लेट अस सी द क्लॉज 2. Clause 2 is very easy. This says the state shall not make any law which take away or abridges the right conferred by this part, any law made in contravention of such clause to that extent be void. They are saying, first thing, state, कौन सा क्लॉज 3 है शिवानी? कौन सा क्लॉज 3? क्लॉज 2 है बेटा. कौन सा क्लॉज 3 पढ़ाना चाहती है तू? इट्स क्लॉज 2 है. कोई बात नहीं, मोदी जी ने अभी नहीं बोला है लाइट जला दीजिए बेटा, ठीक है, हमें 4 दिन बाद कल चलानी है, टेंशन क्या लेती है, ठीक है। इट्स क्लॉज टू, मैं चश्मा नहीं लगाया इसका मतलब ये थोड़ी कि मंदा हो गया, देख अभी भी क्लॉज टू ही है, चेंज नहीं हुआ। चलिए देखते हैं। द स्टेट शैल नॉट मेक एनी लॉ which takes away or abridges the rights which conferred by this part, and any law made in contravention to such clause to the extent of the contravention period. This is first thing is the state will not be making, the state will not make any law against or in infringement to, in abridged to part 3. This is one thing. This is the general declaration that the state should not be making anything which is abridging the fundamental right. Yeah, part 3. This is the second part. This says such law to such extent. This is to the law. I'm using this to that extent. To the extent of contravention is void. To the extent of this is contravention. The first of state will not make any law. This is clause 2 is talking about post constitutional laws. One thing is clear, that basically it is talking about post constitutional law, that once the constitution has come into existence, you have the state have power to legislate law. Where? Patana. Tanu, bol. State have power to legislate law. Where? Very good. Sneha, where is the state have power to legislate? Where is the power to legislate? Very good. Very good. Any person who can tell? Shreya Bhatnagar, बताइए. Where is the power to legislate?
Part 3.
Very good. Part 3 of what?
Constitution.
Constitution. Where is which? Tell me the article. Where is the article where the have power to make law?
Sir.
Okay. Piyush, tell me.
Sir, part 11.
Section article 245 and 246. State means 245 and 246 and even 248 and everything. So
258.
but the basic is 245 and 246 talk about the power of the state at the center to frame laws. So 245 में center and the 246 में state. यानी कि state government have power to legislate law. So we're saying you have a power to legislate law, but you cannot legislate law in contravention to clause 2. In contravention to article 13. When it means article 13, it means in contravention to part 3 of the constitution. The legislature does not have power to legislate law in contravention to part 3. They can do anything else, but they cannot declare law, make law in contravention to part 3. This is the general declaration. And what is the next part? This is the power of, to that extent it is in contravention is void. To that extent the contravention is void. What does it mean to that extent of the contravention? That means that basically they are talking about, they are also saying that that whole such law is not need to be declared, not need to be declared void. That whole of such law is need not to be declared void. Rather, the portion which is inconsistent, the portion which is in contravention is to be declared void. Only the portion that contravenes part 3 is to be declared void. This is here the theory of doctrine of severability or doctrine of separation applies. So clause 2 basically talk about doctrine of severability, severability. तो सीवियर कर दो उसको. The doctrine of severability or doctrine of separability. Doctrine of severability or separability. That means if that part of the legislation can be removed, and after the removal, that part, after removing that part, if the legislation can stand on its footing, then there is no need to declare whole law void. Rather, only that portion is to be declared void. This says it is the duty of court to declare whole law as void as a last resort. So first, it is the duty of the court that it should declare it. The whole law should be declared void as a last resort. Then what? Then what the court should do? It should declare only that portion which is inconsistent या contravention. I will not use the word inconsistent because वो first clause में use किया है तो वो conflicting सा हो सकता है. Which is contravene, which is in contravention, which is in contravention to part 3. It should declare only that portion which is in contravention to part 3 to void, and see if the law or legislation still stand on its footing. So this is if the question of, for example, if you say Information Technology Act, Shreya single case, what is happened in this? Not Shreya Bhatnagar, ऐसे हंसने की जरूरत नहीं है तो शेयर, ठीक है. What was happened? The Information Technology Act, Article Section 66, capital A, was declared void. So what Supreme Court did? It does not declare a complete Information Technology Act void. Only that particular clause was declared void, and after declaring void, they see that whether removing 66A will have any effect upon the enforceability and functionality of the Information Technology Act. If it does not have any effect upon the enforceability and functionality of Information Technology Act, then there is no need to declare Information Technology Act or Amendment Act as void. Rather, that particular section, the provision which is inconsistent with the or in contravention to the part 3 is to be declared void. This is how they work, and this is known as, this is to what the court should sever the contradicting part from remaining legislation. So it is the duty of the court to remove the contradicting part. So this is the US doctrine. This is US doctrine, and you have to remove the contradicting part. Act should stand still on its footing means, what does it mean? Basically, you have to see now, suppose the provision which they are declaring void is of such a vital importance or is such a vital section that if it is removed, it will end the complete purpose of the legislation. Then you cannot declare only that provision. Then that is the last resort. Then you have to declare complete legislation void. But if that particular legislation is standing still, firm, serving the purpose and objective and the principles on which it is being framed, even after removal of that provision, then there is no need to declare complete legislation void. Rather, you have to declare that particular section void. This is known, what is known as doctrine of severability or doctrine of severability. Okay, so you have to separate it. Okay, so you have to follow the doctrine of last resort, and you have tried to find the last resort. Your last resort will be to declare the complete law void. वो last resort कब आता है? जब वो provision इतना important vital है, इतना pivotal है कि अगर उसको हटा भी देंगे, तब हटाने के बाद वो law stand ही नहीं कर पाए. तब. So this is known as doctrine of severability. So this is what the post-constitutional laws not allowed to make. If you make it, they will be checked through the judiciary, and if it is found that they are unconstitutional, they will be declared void. But how important is this? So we have understand 13.1 and 13.2. How many people have understand this concept 13.1 and 13.2? Please. Any person have not understand 13.1 and 13.2? Please tell me. All have done? Let us understand. Let us go into clause 3. Important is this. What we are discussing basically is the law. They're saying either it's a pre-constitutional law or post or last resort. We'll understand again. So we are discussing pre-constitutional law and post-constitutional law. So we should know what do you mean by law. So basically 13 clause 3 talk about what is law. But before getting into this, let me explain you this article 13 clause 2 once again. As Ajuni is saying, so what is happening? So suppose court has a question of this complete legislation. This is in question in which this particular provision is unconstitutional. Court is checking this particular provision. Now what to do? This particular provision is to be checked. What happened, what regard to this particular provision has to check. Court have two options. First, to declare whole legislation void. This is the first option it have. Second option, to declare this provision void. This provision, यानी कि particular section to be void. Court have two options. Either it can declare whole legislation void or it can declare the particular action. What in serving the essential provisions is to be done at last resort. What is to be seen? Court will always follow this first. The court will always will declare void this section. Once it is declared void, it will check after removing of this section. After removing this section, will this act will function effectively? After removal of provision, will legislation act effectively? If yes, then there is no need to declare the legislation void. If yes, no need to declare the legislation void. Declaration of the provision void is enough. Declaration of void. Declaration of void of provision is enough. Declaration of voidness of section or provision enough. But suppose if no, that means if it does not effectively work. If it does not effectively work, then what? Then court have a last resort. It's a last, then last resort. Last resort means आखिरी रास्ता. That is to declare the whole legislation void. So that is the last resort. So you will not be declaring whole legislation void at one go. Okay, and this is what we know as doctrine of severability. If you try to doctrine of severability, यानी कि you try to separate the inconsistent or inoperative or contradictory part from the main legislation, separated, and then read the legislation. If after removing that part, still the legislation is acting effectively and very importantly, it is serving the purpose for which it is being made. If yes, then there is no need to declare the legislation void. It is enough that you have declared a particular provision right. For example, 66A of the Information Technology Act. However, if after removing that particular section, if you read the legislation is not serving the very purpose from which it is made, then yes, then the last resort is to declare the legislation void. This is known as doctrine of last resort and doctrine of severability. How many people have understand this? I think everybody has understand this, right? Chaliye, let us go into the third clause. That means what we are understanding is that the constitutional law, Article 13 basically is saying pre-constitutional law or post-constitutional law. They are saying either it's a pre-constitutional or post-constitutional law. They should not be in contravention or inconsistent. We have understand the meaning of inconsistency and in contravention. They should not be inconsistency or in contravention to part 3 of the Constitution. The important is what is law. So pre-constitutional law or post-constitutional law. In both the situation, important is law, and therefore we should understand what amount to law in Article 13. Article 13 clause 3 defines law. And this definition is very exhaustive. So this definition of law is very exhaustive. And third, so let us read what they are saying. The article, unless the context otherwise. So this clause says, what do you mean by unless the, we know this, what does it mean? Unless the context otherwise. Unless the context otherwise. What does it mean, unless the context otherwise? This is unless the context otherwise. The law includes. What does it mean, unless the context otherwise? That means if there is no other definition given in part 3 of the law means this for the purpose of Article 30. If no other definition, if no other definition given, then law means. They say first, law includes. This is an inclusive definition. This says first, this is law includes any ordinance. They're saying ordinance is a law. We know what is ordinance. Order, bylaws, rule, regulations, notification, custom, or usage. The clause 1(3) ka clause A. 3 clause A says law includes. This is an inclusive definition. This is very inclusive definition. Open-ended definition. This is open definition. It's include many other things. So they are giving ordinance, order, bylaws, rules, regulation, notification, custom, usage can be law. What is important is this is having in the territory of India the force of law. This is important for us to study, the force of law. देखिए, the word ordinance, order, bylaws, rule, regulation, notification, custom and usage are being suffixed by the phrase the force of law. Each ordinance is, so what is ordinance we know, what can be a bylaws we know, what are rules we know, what are regulations we know, what do you mean by notification we know, what do you mean by custom we know, what do you mean by usages we know basically. But each custom, each usage, regulation, bylaws will not be law. These ordinances, these regulations, these orders, when it say orders, it means administrative orders, it means executive order. Anything can become law for the purpose of Article 13 if it have a force of law. And this is the important, the suffix word force of law. If you see in clause B, they use the word law enforce. Where is in clause, if you see the clause 13 ka B, they use the word law enforce. Whereas in clause A, they use the word force of law. So there is a logic behind using it. The force in law enforce, and force of law. Why they are using the word force of law? Because they're trying to tell you which type of ordinance, or which type of custom, or which type of laws can be considered as law for the purpose of Article 13. The word force of law basically, if I say in a general term, I don't go into jurisprudential essence because usme fir wo settlement and everything has defined all this. Before going to the simple thing is this: the law which can be enforced in court of justice. That means any ordinance, any order or any bylaw, any rule or regulations or notification or custom or usage which can be enforced in the court of justice, यानी कि जिसके खिलाफ remedies available हैं court में, they will be considered as. So basically the force of law means those above the given systems which can directly be enforced through courts if they are enforceable in court. They are law for the purpose of Article 13 clause. Article 13. Right. So use of force of law is so that they can do any executive order or any administrative order which can be enforceable in the court of law. That means that can be considered as a law for the purpose of Article 13, and it can be checked upon the litmus test of constitutional part 3. Okay, so it's force. What do you mean by law enforce? What do you mean by law enforce? Law enforce. That means law, general law framed by the legislatures or the parliament. Law framed by parliaments. ठीक है, तो 245 के laws है, 246 में, 47 में, 48 में, 49 में, 53 में, and so many other provisions are there to where the parliament have power to make laws. But it does not include 368. We know this, है ना? We know this. But basic structure can be checked. We have understand this when we are studying 368 completely. और core clause form में declare भी कर दिया, ठीक है? This is what Article 13 basically is. So how many people have understand Article 13 अच्छे से?